Yeah, sure. The Commonwealth is moving to introduce a Google search the defendant conducted at 1:27 p.m. on January 29th, 2022. The Commonwealth would argue that the probative value of this Google search outweighs any prejudice to the defendant. The search in question is at 1:27 p.m. before the defendant had spoken to law enforcement. She conducted a search for DUI attorneys. The Commonwealth thinks that this is appropriate for the jury to hear as it rebuts the Bowden defense that the defendant has laid out. Not that she did not intend to commit John O'Keefe. The defense has been that the defendant is essentially what's been represented in opening court was framed that she had no intent or opportunity to commit these crimes. Further, that she was not intoxicated at the time. So the Commonwealth feels that the probative value significantly outweighs the prejudicial value. It goes to her state of mind at the time that the search was conducted. Further, it also rebuts that there was any impropriety in the police investigation, or that, as the defendant has put it, that the police did not search any or investigate any other potential culprits. It also would go to the defendant's consciousness of guilt at that time. This statement is before she voluntarily gave an interview with law enforcement. It goes to her state of mind prior to that interview. And so for all those reasons, the Commonwealth would suggest that that Google search is appropriate, and it's not a typical case where it's an invocation of counsel, where law enforcement had not engaged her, and it goes to her state of mind at that time prior to any police involvement, and further to rebut that there was any improprieties in the police investigation, or that they should have investigated anyone else.
All right, and I appreciate, Mr. Lally, you bringing this to our attention to give us time to look at it. Ms. McLaughlin, I appreciate that you provided a very strong limiting instruction proposal. I'll hear you, Ms. Giannetti.
Thank you. Your Honor, you had asked that I produce proof of the phone call from Michael Proctor to my client.
Oh, I didn't say proof. No, I asked if that was coming into evidence.
Okay, well, I'd like this marked for identification for the purpose of this argument, if I could.
Sure.
Show counsel. It's been redacted.
Okay. So let's have it marked for ID before I hear you any further. So Madam Court Reporter needs to mark it.
Triple L for identification.
All right, and if I may have that. Thank you very much. Just give me a minute, Ms. Giannetti.
Of course.
All right, so this is just that a call occurred, right?
That a call was made from Michael Proctor's personal cell phone number, you can see the last 4 digits there, to my client at 1:19 p.m. on January 29th.
Okay.
Approximately 8 minutes before she calls to investigate a potential DUI attorney.
Okay, so focus on the law for me and tell me why I should exclude this.
Of course, yes. With regard to the cases that the Commonwealth has cited, I think the court has seen, one of them is an unpublished opinion, the other is a homicide case. They couldn't be more distinguishable from this case. With regard to the unpublished opinion, that appears to have been a gun charge where the defendant in that case did a search for a 9mm handgun on his cell phone. He did not ask for Google or search in Google for a handgun attorney. He made a specific inculpatory search that the court ruled was relevant, and it was not outweighed by the danger of unfair prejudice. In this case, we have a person being contacted by the police and then doing what a citizen has every right to do, which is to look for an attorney for representation. There's zero probative value to that, other than she's presumed to be innocent and she's seeking an attorney to defend that presumption of innocence. That's it. There's zero probative value. But there's an extreme and unfair prejudice in this case. Your Honor, the limited instruction that the Commonwealth has provided ask this court to instruct the jury whether her action in doing an internet search for an attorney indicates feelings of guilt by a defendant. I can't even believe that argument's being
So
made.
let's just focus on the
Well,
law.
I'm trying to, Your Honor. I'm
All right.
flabbergasted.
So what I'm going to do then is I'm going to stop you. So on the balancing act that I have to do, I find that the probative value is outweighed by the prejudicial impact.
Okay.
All right. So I'm not going to allow it in, Mr. Lally, in your case in chief. Now, if you feel that through this witness or through any other witness, Mr. Lally, that it then is admissible, I just ask that you come to sidebar beforehand.
Absolutely, Your Honor.
Okay. I'm going to allow it.